Fox Oldies, 98.9, 105.3, WGNY FM in New York. It's a fun day Saturday morning. I'm Bobo, my very special guest with Planning Ahead. Megan, good morning to you.
Good morning, Bobo. How are you today?
Well, not too bad for an old guy, as I always like to say. Hey, tomorrow's the first day of summer, coming in at 4-something a.m.
Yes, that's so exciting. The spring has been wonderful. We've had great weather, but I am excited for some summertime.
Oh, yeah, why not? As long as it's not too miserably hot, that's for sure.
Right.
So, Megan, tomorrow's also Father's Day.
Yes. So it's that time of year. Happy Father's Day to all the dads.
Yeah, and may they continue getting a tie. Oh, brother. Megan, how about your contact information?
Absolutely. So my name is Megan Conroy. I'm a partner at Blustein, Shapiro, Frank, and Barone. We're located in Goshen, New York. Our phone number at the firm is 845-291-0011, and our website is www.mid-hudsonlaw.com.
All right, Megan, subject matter, probate. Nobody really wants to go through probate with somebody's last will and testament. So how do you avoid probate, Megan?
Absolutely. And so this is something that my clients say they want time and time again. But what I think is really important is to understand what probate is so that we know why we might want to avoid it. And probate is really just a court process whereby the court validates someone's will if they have a will. So a lot of times people will say to me, well, I have a will, so I don't have to go through probate. Isn't that right? No, that's not correct. How your assets are titled is going to determine whether you go through probate or not. Anytime we do need to rely on the will needs to be probated. The court needs to verify it so that they can make sure it's properly executed. But so why do people want to avoid probate? Well, they don't really want to go through that court process. But what's involved in the court process is typically added expenses. There's court filing fees, attorney fees, things like that. And the court process lends itself to other people coming into the picture that maybe we hadn't anticipated. So if we have a will and the will describes who we want to be our executor and how we want assets to be distributed, other people might be able to come in that court proceeding and say, well, I really think I should be the executor. I disagree with this will. I disagree with Megan's wishes. Or I think I should have been a beneficiary. I believe I'm owed something by Megan. Or maybe she didn't pay all of her debts, and so now I'm a creditor of Megan's estate. So it's really these unintended consequences that people are trying to avoid when they're telling me that they want to avoid probate. And we can avoid probate pretty easily. We just want to do that through a cohesive plan. We really want to make sure that all the pieces are connected, and through that coordinated estate plan, we can easily and successfully avoid probate.
Wow. I know with my brother's last will and testament, probate could not be, what's the word I'm looking for? Probate could not
avoided.
Probate could not be avoided. What happens there when that happens?
Sure. So after someone passes away, that's really too late to consider how we're going to avoid probate. Whatever version of the assets are at that time, however they're titled at the time the person passes away, that's sort of it. So what we want to do, obviously prior to passing away, is do some good estate planning, address our assets so that we can hopefully allow for our families to inherit the things we have without too much trouble, without court intervention, and without unexpected consequences. So through a coordinated estate plan, we can avoid probate basically by looking at how our assets are titled. There's 3 ways that you can have assets titled before you pass away. There's individually titled assets. So let's say that's going to be, I have a checking account down at the local bank. It's the Megan Conroy checking account. I've never added a joint owner to my account, and I've never added a beneficiary to that account either. That's an individually titled bank account. So if I pass away, my husband goes down to the bank and he says, unfortunately, my wife has passed. I'm looking to collect this bank account she has. The bank has to tell him, I'm sorry, sir, but we can't just give you this money. We don't see your name anywhere. We don't know what Megan's wishes were. So you now need to go through this court proceeding, this probate proceeding, in order to get court authorization to collect this account. So it's because the account was individually titled at the time I died that now my family has to go through a probate proceeding. And if I have a will, during that proceeding, my husband would submit my will to the court for review and approval. If I don't have a will, the court is going to look to the state statute to see who can be appointed as my executor, in this case called an administrator, and who my beneficiaries should be. So the will is just serving as instructions to the court, but we're only using it when I have probate assets. Those are individually titled assets with no joint owner and no beneficiary. So sort of the reverse of that is if I have something that has a joint owner or I have an asset that has beneficiaries on it, those assets typically are not going to go through probate. If I had owned that checking account jointly with my husband, when he goes down to the bank after my passing, they say, I'm sorry, sir, we're sad to hear that your wife has passed away, but fortunately you are an owner on this account. So you continue to own this account even though your wife has passed. So now he doesn't have to go through that probate proceeding because he was a joint owner on the account, and so he still has access to those funds. Different than that is beneficiary designation. So if he was not an owner on the account during my lifetime, but I was wise enough to put him on as the beneficiary, after I've passed away, when he goes down to the bank tellers will instead say, we see that you're not a joint owner on this account, but your wife did designate you as a beneficiary. So we'll give you these funds because you're listed here as a beneficiary on the account. So joint ownership and beneficiary designations do not have to go through that court proceeding, that probate proceeding. That happens a lot more quickly. My husband can receive those funds.
All right. So in this particular case, if the deceased happens to leave monetary gifts for a couple of individuals, but the last will and testament is still going through probate, what happens there? Why does that have to go through probate if there's a couple of other people listed as beneficiaries?
Sure. So sometimes we do see a combination, right? We'll see certain assets are titled with beneficiaries and other assets are titled in a way that will end up being probated. So this is very common and why we want to use a coordinated estate plan so that we don't leave some items out. I would say the most commonly probated items would be real estate, like someone's house or vacation home, etc., and vehicles, because those things are really hard to put beneficiary designations on, and we want to be careful about how we jointly title assets because there could be other implications to that. So a lot of people are great about putting beneficiaries on their investment accounts, brokerage accounts, retirement accounts, life insurance, and even annuities. But then they sort of don't do anything to address their primary residence or even other real estate that they may own. They sort of forget about the car and that the car has a title, a form of ownership. And so there could be pieces that go through probate and then other things that are quickly distributed through beneficiary designation. Sometimes, depending on what the will describes, people don't realize that certain assets will avoid probate, and so their will might describe that those same assets go to a particular person under the will, and meanwhile the beneficiary designation on the account itself doesn't match those things. So again, this comes back to more of a cohesive estate plan to make sure we don't have conflicting instructions, to make sure all of our assets are accounted for, and to make sure the things that we want to get to the people that we're designating really make its way there as quickly as possible.
Wow. Now, what if the last will and testament has to go through probate, and it's taking a while? What if a partial payment is due to those beneficiaries that are going to gain monetarily from the last will and testament? In other words,
Sure.
why would an individual have to go through such a thing like child support background when their kids are already 40 and 50 years old? And why would there have to be a background check of the deceased's estate?
Mm-hmm. Good questions. So these are some of the reasons that we try to avoid probate, right? These unexpected consequences. And it's different between different jurisdictions, but generally what happens when we go through probate, that court proceeding, which only occurs because the decedent owned assets in his or her own name, they weren't jointly titled, they didn't have beneficiaries on them. So now no one has immediate access. We have to go through the probate proceeding. When the court is overseeing this proceeding, the court wants to make sure that all of the decedent's debts are paid. So whenever we're looking into maybe the background of the decedent, or we're doing some searches on things like real estate, looking for liens and judgments, that's because through the probate proceeding, the decedent's debts have to be paid first. So the creditors, the debts of the decedent, they're kind of the first beneficiary of a probate estate. And generally people don't realize that. So when we're looking into the decedent's background, we are looking to make sure that if they had any debts, those debts can be addressed. They can be probably negotiated down in many cases and then paid off. And then whatever's left of the assets after that, that's what goes to the beneficiaries under the estate. But the second part of your question is, what about looking into the beneficiary's background? Well, sometimes the beneficiaries also will owe money. They may have judgments or things like back child support, money that's owed to certain people. And certain kinds of judgments take precedent over other kinds of debts. And so the court also has a responsibility of making sure that if there are these kinds of special judgments against a beneficiary, the inheritance that the beneficiary is set to receive is used to pay those judgments and debts off first before the money is released to the beneficiary. So that's one of the problems with probate, is that unfortunately it means that all of the creditors of all of the people are going to get paid before the beneficiary actually receives the funds.
Oh, sure, absolutely, and I can see that. That's for darn sure. But when you talk about this child support, and if the beneficiary had children and they're 40 and 50 years old, is that still going to be looked at?
I suppose it could be if the court is really trying to be very thorough in making sure that the beneficiary doesn't owe any special kind of judgment or debt. And child support is going to be one of those special judgments, right? So if someone was delinquent on their child support, they never paid it, a lot of times the family has a hard time enforcing that down the road, finally collecting the money that was due to the children. And so this is going to be something that stays with that individual, the person who didn't pay their child support or got behind on it. And it stays with them for life because really that money is owed for the children no matter how old they are. And so the court wants to make sure that if this person who's owed child support all this time is suddenly getting this huge distribution from an estate, that some of that money does go towards the back child support, the debt that's owed, regardless of the children's ages.
Wow, so back child support on any beneficiary, doesn't matter, male or female, is definitely going to be looked at. And if anything is owed, those monies will definitely come out of that individual's inheritance then, yes?
Sure. I don't know that I'd say definitely, but it's a high probability that whether it's child support or other debts, that is something that could come out of the inheritance that the beneficiary is expecting. It's all situational. It's definitely going to depend on the circumstances, but I think it's something that we should account for when we're doing our planning.
Wow. So overall, time-wise, if there is a background check being run on the deceased estate, how long does that usually take?
I don't know exactly how long a background check can take, but I don't think that's going to be the thing that leads to most of the delay. So it might take a little bit of time just to make sure that we've accounted for all of the debts and expenses and things of that nature. But really, a lot of the time constraint comes from the court process generally. So here locally for us, I would say a probate proceeding typically takes about a year from start to finish.
Whoa.
And that's because it takes a little while to get paperwork prepared and circulated amongst the people who are required to sign off. Then it gets submitted to the court, and the courts try to move as quickly as they can. They're really very good about this. They don't want these estates lingering, but they have a lot of files in front of them. So from the time the file is submitted to the court to the time the court gets a chance to review it and appoint the executor, that typically will take somewhere between 2 to 3 months. And then once the executor is appointed, now they have a job to do. Now they have to determine what assets exist, what debts exist, what can they negotiate down, how can they collect things, and they can't make distributions to the beneficiaries for a period of 7 months from the time they're appointed. And that's because creditors are allowed to come in within that 7-month period and say that they're owed some money by the decedent, or for some reason they should be getting some of the funds out of the estate. So the executor has to wait the 7-month period to see who comes out of the woodwork, who's entitled to funds, verify them, and then get them paid. Then once all of those things are paid, the executor can finally pay out to the beneficiaries and close out the estate. So where there are no issues whatsoever, that is the process, and it takes about a year from start to finish.
Wow.
If there are any issues, though, right, so people saying, wait a minute, I want to be the executor, or I don't think this other person should be appointed, or wait a minute, I am a disinherited child, and I think I shouldn't have been disinherited, that's going to draw out the process even further. So I would say the minimum amount of time is a year, but it can go on for several years.
Wow, that is absolutely amazing. Now I know why people don't want to go through probate, correct?
That's right. And like I said before, it's easy enough to avoid if you just think about all of your assets as a comprehensive picture, and then each asset you'll address by making sure that it's titled in a way that doesn't go through probate. It's jointly titled with a spouse, or it has beneficiaries designated on the account. And then through estate planning, we also use trusts, and trusts can help us to avoid probate as well. So using those different tools, we can avoid probate. We just have to go asset by asset to make sure each one is addressed.
Wow. So for an individual, people that are inheriting monetary figures from a deceased individual, do they also have to appoint a fiduciary?
So are you asking about the beneficiary appointing a fiduciary?
Yes.
Okay, so not typically. They don't have to appoint anyone. They might work through fiduciaries. So if they feel like they need to be represented in the court because they're afraid they might not be receiving the share they're entitled to, they may hire an attorney to represent them. Or in anticipation of the inheritance that they're getting, they may begin working with financial advisors and things of that nature. But being a beneficiary doesn't mean you necessarily have to hire anybody.
Oh, okay. Okay, I just wanted to make that clear for all the listeners, and myself, too, to be honest with you. Megan, how about giving us your contact information again?
Absolutely. So the law firm is Blustein, Shapiro, Frank, and Barone. A good phone number for us is going to be 845-291-0011. The website is www.mid-hudsonlaw.com, and that website has a lot of resources on it. There's also a way to sign up for our free workshops. So for those listeners who do want to learn a little bit more about estate planning, I do host a workshop every other month, and it is free and available to the public. You can sign up for that on the website.
Yeah, but people should sign up because seating is very limited, correct?
That's correct. Because we do these workshops in person in our office, the seating can be limited. It's about, I think we can fit about 20 people. So as you can imagine, that fills up pretty quickly. Our next workshop is going to be on July 22nd, and then the one after that is September 10th. And they're all held in the office right in Goshen in our education center there. And so you can sign up online or call over to the office, but you should sign up because those seats do fill up.
That is absolutely awesome. Now, Megan, this probate thing is, wow, it has my head spinning. And I can see why, with the information that you've given all of us, why you don't want a last will and testament going into probate. That's for darn sure. It sounds really complicated and really could be very, very expensive, yes?
Yes, yeah, sure. The costs can add up. So when there are no issues going through probate, typically you still have court filing fees and attorney's fees so that the anticipated executor or the beneficiaries, they know that someone is guiding this process. So there's costs associated with that. But then when there are issues that crop up, sort of those unintended consequences, then those fees tend to get larger because now the attorney has to do more work. There may be more professionals involved than what we originally started with, and the process is going to go on for a bit longer. So you're going to see those fees accrue.
Wow. I mean, it's unbelievable to think that if someone's last will and testament has to go through probate, depending upon the circumstances, of course, it could take a couple of years or a few years, not just a year, right?
Absolutely. So I would say a year is about the minimum amount of time that we'll typically see for a probate proceeding. Again, from start to finish, including preparation of the paperwork all the way to the closeout. But I myself have seen estates go on for several years, 6, 8 years even. And it's because there are things that occur during the proceeding that, again, were unexpected by the decedent and caused a lot of delay and a lot of hiccups. So it can go on for a long time. And that means that beneficiaries can be waiting all of that time before they receive a distribution.
Wow, that is just crazy. And I guess a beneficiary could turn around and see their inheritance just dwindle down to practically nothing, I guess, right?
Absolutely, yeah. Sometimes the costs associated with the proceeding itself are so exorbitant that it takes a big chunk out of the estate. And that's typically a conversation that we want to have with a person who contacts us to say, hey, my loved one has died. I think I'm named as the executor. I'd like to proceed. When we start to gather the information, if it seems likely that the costs are going to be exorbitant, we warn them of that and that it could potentially mean that there's not a lot left at the end of the day, or especially if there's a lot of debts associated, so the decedent owed a lot of people a lot of money, then it could turn out that the estate is sort of upside down and that those debts are going to get paid off first and leave nothing for the other beneficiary.
Megan, let me ask you this question. Being executor of a last will and testament is a huge responsibility that people really need to know about, correct?
Absolutely.
So what if that individual doesn't want to be the executor of that last will and testament? What happens then?
Sure. So anyone who is nominated in the will is never going to be forced to serve. So typically that's something that we want to discuss with them when they contact us, is that they know what to expect and what their responsibilities are. Sometimes when I'm doing planning with people, they say, oh, I'm going to name, child A as my executor, but then I think child B might feel bad that I chose child A. And I have to remind them, this is not the person who's inheriting assets. That's not what you're picking here. You're tasking someone with responsibility. It's a lot of work. It's a lot of paperwork and a lot of phone calls and a lot of headache. And so a lot of times we want to take that into consideration right at the planning stage when we're designating someone for this position. We don't want to pick someone who would not be inclined to do that kind of work or can't be counted on to do that level of work. Then when the time comes for that person to serve, again, there's an assessment made. We tell them that this is, again, a lot of phone calls, a lot of paperwork, a lot of time to be invested in this role. And if they don't think they can do it, either because they don't want to or they have things going on in their own lives and they just can't take on another task at this time, they should say that at the outset so that we can move to the next person that's listed in the will, or if there's nobody else listed in the will or there is no will, we can look for someone else who might be willing to take on that responsibility.
So the deceased now, what they would do with their last will and testament, and correct me if I'm wrong, they would probably list, 3 other people that they would like as executors, yes? And they would be picked from that?
Yes. So we do like to have a sort of a succession plan in place for the executor position. So a lot of times if it's a married individual, they might say their spouse first, and then if their spouse can't serve, say adult child A. If adult child A cannot serve, then adult child B. And we can put as many people on that list as the person who's preparing their will wants. But typically we like to have 2 to 3 on that list to account for the fact that these people may not be living or may not be willing to serve as executor when the time comes.
Now, would they have to be put in order, like person number 1, person number 2, person number 3, et cetera, et cetera?
Yes, we do try to list them in the order that we would want them to serve, so sort of a preference. And again, the preference is not, I like you better. It might be, but usually it's not. It's, I think you're most suitable for this position. And if you're not available, I think this next person would be the next most suitable person for this position. And it could be based on what they do in their career, right? Maybe they're very financially astute. They work in the financial industry, and that makes them suitable for this. Or they're local, and that makes it easier because there's going to be a lot of banking institutions to run around to. And so we want someone who has boots on the ground, can do all of that legwork in person. So there's a lot of factors in determining who's appropriate for the position.
So what if here, hypothetically, that the deceased has 4 people in order, in succession, of who that individual would like as an executor, and none of them want to be an executor? What happens then?
Sure. So there's a statutory provision that the court will look to see if none of the people on the list want to serve, who legally would be entitled to serve as the executor or administrator. So there's going to be the opportunity for family members, close family members to serve. So even if they're not listed, they can come in and say, you know, I wouldn't mind doing this job. Beneficiaries designated in a will can serve even if they're unrelated. And in fact, even creditors of an estate can serve because they have an interest in this estate. They're due money, and so they are interested as a party, and they can serve as well. And if we really got through all of the potential people, so none of those people that would statutorily be entitled to serve want to serve, then the court can actually appoint an independent person they choose off of a list who would then serve as the fiduciary, as the executor or administrator of the estate. So someone totally unrelated to the proceeding.
Oh, I see. In this particular case, though, could it be that individual's attorney that could become executor?
Having the attorney serve, I would say, is a little unusual. If the person designated the attorney as a potential executor in their will, so maybe I served as the attorney for a dear friend. I put their estate plan together and they say, you know what, Megan, if all of my family members couldn't serve, we're so close, I would love for you to serve. Even though you're my attorney, you're also my friend, I would want you on this list. Sometimes we see that, but otherwise we don't often see the attorney serving as the executor. It's not to say that it's impossible. It certainly is possible. Like I said, if they designate the attorney, then certainly the attorney is entitled to serve. But otherwise, you're not going to see the attorney get involved in that capacity.
I see. Okay. Hey, Megan, how about your contact information again? One more time, please.
Absolutely. So the phone number for us is going to be 45291-0011, and the website is www.mid-hudsonlaw.com. And again, if you're interested in those free workshops, you should either call or go on the website to sign up for them of July 22nd and September 10th.
And they take place in your Goshen office, correct?
That's right. In the Goshen office, they run from 3 to about 5:15 p.m. So it's a longer workshop. We do provide snacks in case anyone gets a little bit hungry, but it really goes through everything regarding estate planning basics.
I would like some Cheetos.
I'll take that into consideration.
Megan, you know what? You are just absolutely so wonderful. And again, I have to thank you for your valuable time and your valuable information with planning ahead. You are just awesome.
Thanks, Bobo. You're always wonderful to chat to on these Saturday mornings.
Well, I try to be, for an old guy. What can I tell you? Hey, I wish your husband a very happy Father's Day, Megan.
Thank you so much. Same to you and all your loved ones, Bobo.
Absolutely. Now go out and get him a nice steak so he can grill that, about 2 inches thick.
That's it. How did you know? My husband is the cook in the house.
Especially when it comes down to the grill, I'm sure, right?
Oh, yeah.
All right, Megan. You have a pleasant Father's Day with your husband. I hope your kids have a wonderful time. And tomorrow, the first day of summer. Oh, boy, bathing suit time.
Enjoy it, Bobo.
You too, Megan. Take good care of yourself.
All righty. Bye-bye.
Bye-bye. All right, there she goes. Yes, and she is one heck of an attorney, let me tell you. And you should go see her. Make an appointment. Get into those free workshops. You're definitely going to want to do that. Hey, planning ahead. I'm Bobo, and I have more of the greatest music ever recorded coming up next right here on Fox Oldies 98.9, 105.3, WGNY FM in New York.